morning, America. This is Greg Brown reporting to you directly from the Washington State Penitentiary. Today is Saturday, September 28, 2024, and I'm here to report to you on the more corruption and abuse engaged in by your Washington State Department of Corrections. Now, in my presentation on prison reform, I had talked about how this Captain Morgan, I had filed a lawsuit against him and then the Department of Corrections because Captain Morgan and his minions at the Washington State Penitentiary, where I am now, they confiscated my legal papers and stopped me from appealing my conviction. And this is why I'm in prison right now today, because he stopped me from appealing my case. Well, I filed a lawsuit on that under Brown versus Morgan in the United States District Court for the Western District of Washington. Under number 16-CV-05975. And I'm talking about that because I'm talking about a long pattern of corruption, especially involving Richard Morgan and numerous other prison officials engaged in a long conspiracy to disrupt prisoners' right of access to the courts and to take it all the way and to block us to where we can't file anything in court anymore. Now, in that presentation, I also talked about corrupt judges, horrible, corrupt decisions, and I talk about the guards in Walla Walla again. This time, they refused to give me my mail that was sent to me from the court. And they did this so I would not know. The court had told me to go ahead and amend my lawsuit against the prison guards. By not allowing me to know what the court had said, they got that lawsuit dismissed. Well, then this United States District Court Judge, Benjamin H. Settle, flat out lied on me in order to prevent me from prevailing and to cover up for the guards and for the Department of Corrections to keep me from being able to get this case reopened, the one that they had just gotten dismissed. Now, some of you wanted to know why the guards and the court would go through so much trouble to stop me from pursuing this lawsuit. Well, the answer to that is because my lawsuit exposes the Department of Corrections committing a whole lot of corruption for years and years, going way back into the 1980s. And they have absolutely no way to deny it or to defend against my lawsuit. I had written it up in such a way, so well, to where they would have to just bow down. I filed this lawsuit against them. Another reason is that my lawsuit shows that this same Captain Morgan was eventually promoted all the way up to being Secretary of Corrections. It shows how DOC protects and promotes their most rotten employees all the way to the top. Imagine how it feels now with a Secretary of Corrections over to all prisons, and he's the one who stole all my legal papers and stopped me from appealing my criminal conviction. Also, in this, my second amended complaint of the same lawsuit, dated April 28th, 2017, I talk about the DOC program manager, Roy Gonzalez, and the Clallam Bay Correctional Center, law librarian, Barbara Gronseth, destroying all of the prisoners' self-help books and telling us prisoners that we can't talk to each other anymore in the law library. And like I said, I would have won this lawsuit hands down if they had not refused to give my mail from the court. And I'm going to tell you why I would have won. First of all, here's how the law library works. When prisoners sign up for law library access, we are randomly scheduled together in the law library. Sometimes there are too many prisoners because the guards deliberately make the law library too small to hold everybody. Kind of like going to an overcrowded nightclub. If too many people sign up, then some don't get in on the list, and we just can't get in. Because of this, you never really know what other prisoners will be there with you. But if you need to be scheduled at the same time with someone else so you can work together, then you have to submit a scheduling request asking to be scheduled at the same time as the other prisoner. Well, now, during one of the guards' meetings where they're always talking about how to punish prisoners for helping one another, somebody came up with the bright idea of stopping us from talking in the law library. It was suggested that they take this scheduling request process that I just described to you and turn it into a talking request process. A request to talk. Yeah, that's what I said. And they thought they were smart. They started saying that since we have to ask to be scheduled together, then that means we can't talk unless we ask for permission to talk. Man, that shit was corny as hell. But it shows how much thought they put into trying to twist and abuse their rules and do their dirt. You see, because the scheduling request process is to make sure you can get into the law library at the same time as somebody else. It had nothing to do with the situation where you're already sitting right next to someone in the law library. You're already scheduled together and looking at each other. So they started trying to make us prisoners who are already sitting next to each other and looking at each other in the law library. They tried to make us have to get up and go get written permission to talk to one another. If the guy sitting right next to me asked me a question, I would have to say, hold on, partner. We got to go get permission to talk before I can answer your question. And what's more crazy is I can actually receive a disciplinary infraction just for telling him that. I have to actually sit there and ignore him like some kind of weirdo, or I guess maybe try to signal him in sign language. I mean, he's sitting right next to me, about 4 inches away, and I have to try to use sign language to get him to understand we got to go get written permission to talk. Imagine that. And those of you out there who smoke weed or smoke a joint, think about that, because you may fall out laughing. This shit is so funny and crazy. Imagine us sitting next to each other, about just 4 inches between us, and we use the sign language. That's some shit you might see on the Saturday Night Live or something. I don't even know sign language. I tell you, these people are a bunch of lunatics. Unfortunately, I'm sad to say, most of these prisoners, they just go along with it. In paragraph 115 of my second minute complaint, I talk about how the Department of Corrections, they refuse to provide us attorneys to help us with our civil rights complaint. Now, because we're not allowed to talk to anybody outside the prison, did we have to talk to each other? So you see, they did this to stop us from ever being able to win any court case in court. At paragraph 116, I said the talking request had to identify which prisoner is helping whom, so the one who is helping could be punished by having the time he used to get in to cut down. This is what they had told me in the law library, that we have to tell them when we fill out our talking request, we have to say, oh no, I'm the one who is helping him. He's not the one helping me, but I'm the one who's helping him. And that way, they can then look at me and punish me for helping him. So, if I used to get, let's say I got 3 days a week, then when I come back and request time in the law library again, after telling them that I was helping him, then they reduce my time to just 1 day a week. And that's the penalty for me helping another prisoner. Now, let me make this clear. I had to fill out a talking request, and I had to say that I want to talk to the other prisoner. So when I ask to get scheduled for more time in the law library, I get told no, because I obviously don't need the time, since I choose to use my time to help others. In paragraph 116, I said I complained about this to Cronsteth's supervisor, which was Yvette Stubbs, and that Stubbs responded in writing. She said, quote, if a conversation takes over 1/2 of the section, then yes, I would want it in writing who was providing assistance to who, unquote. So she admitted the purpose is to punish prisoners who are assisting others. Now I'm going through these details in order to show that everything that they did, I actually got it in writing. And this is the reason why they couldn't deny anything. I made them sign a paper saying this is what they were doing. So in paragraph 117, I said I filed a grievance number 1354765 because Cronsteth, on about September 26, 2013, confiscated and refused to return a piece of paper from me because the prisoner named as Jelly wrote his name and DLC number on it for me. I also said the grievance coordinator, Hofi, the superintendent, Bob Oberlin, and Secretary of Corrections, Ron Franks, on 12/30/13, upheld Gronseth's actions and actually told me that I should have been disciplined for trying to get as Jelly's name and DLC number. Now, America, I know this may sound a little out of pocket to you, but let me tell you just how dumb and just how out of pocket this is. Now, you can look up the Washington State Department of Corrections policy right now. It's DLC policy 590.500, section Roman numeral 2, and capital 6. And it says, quote, an incarcerated individual assisting another in legal matters may only possess the other's legal documents, papers, while both are in the law library, unquote. So why would anyone say, as Jelly give me his legal papers that has his name and DLC number on it. On top of this, when prisoners are given a disciplinary infraction, or when we file a grievance, we're required to give the names and DLC numbers of any prisoners who want to be a witness in my grievance. How can I do this if I don't have his DLC number or his name? And even court rules, Federal Rules of Civil Procedure 56C4, it requires me to get sworn affidavits and declarations from my witness. Yet these DLC people have become so salacious, foaming at the mouth about stopping us from talking in the law library, so outright and blatantly out of line with the dumb stuff they let fly out of their mouths, to where they can actually fix their mouths to say, I should have received a disciplinary action for getting Astelli's name and DLC number. This is the corruption and the state of mind of the people who run the Department of Corrections. You can't make this shit up. The reason why they had to stop my lawsuit was because they could not come into any court and say the dumb shit that they say unless they already have the judge in their pockets or something. In paragraph 118, I said that when I gave Yvette Stubbs a written kite about this on January 2nd, 2014, Stubbs responded in writing by telling me that reducing the law library hours of prisoners who are, quote, still assisting others, unquote, is justified. By using the word still, she clearly is showing her intention is to discourage and stop us prisoners from assisting each other. She says still. She further threatened to, quote, make it tighter. That's her words, make it tighter, unquote, if I continue to complain. But threatening to make it tighter if I continue to complain, she further opened herself up to being sued for unlawful retaliation. Also in paragraph 116, I said I wrote a grievance about this. On or about February 24th, 2014, grievance coordinator Halsey and the superintendent Frakes and the DLC assistant secretary clarified that the restriction on talking in the law library, quote, only applies to prolonged conversations, unquote, and that, quote, brief encounters are permitted, unquote. And then in the same paragraph, I said I gave Yvette Stubbs another written kite about this matter on June the 2nd, 2014, and Stubbs responded in writing by saying, man, prisoners may talk, quote, 15 to 20 minutes, unquote, without having to fill out a talking request or be bothered by grunt set. Well, okay. We sounded a little better. But then in the same paragraph, I said that on about February 23rd, 2014, prisoner Mario Wilson came into the law library, sat down, and he didn't even talk to anyone. And this crazy-ass Grand set walked over to him and told him to move to another table because he looked like he might want to talk to the other prisoner who was sitting at the table. Mario didn't even know this other guy. Mario ignored Grandset. In this same paragraph, I said that on or about March 23rd, 2014, Grandset ordered Mario to, quote, stop bothering inmate Sergio, unquote. When Sergio said he wants to talk to Mario, Grandset then made Mario physically remove himself from the law library by maliciously claiming that he was being disruptive. To use the word disruptive, quote unquote. Now, in paragraph 119, I said that on about June the 23rd, 2014, inmate Jesse Johnson walked into the law library, just walked in and asked inmate Monahan, and, quote, "Where do we get tort claim forms from?" Unquote. Grosset overheard this and ordered Johnson to stop talking. Johnson looked dumbfounded because this was his first time in the law library, and he thought this was supposed to be a place where people go to ask legal questions. In paragraph 125, I described how on July 25th, 2014, I had just walked into the law library and sat down when prisoner Piget walked in. Big Tate. I said, "What's up, bro?" And Big Tate, he greeted me back. We hadn't even been there 30 seconds yet. Other prisoners were still arriving as Grosset quickly came over and handed Piget and I a kite and ordered us to fill out the talking process. I asked to speak with the shift sergeant about Grosset's misconduct, but she said the sergeant's busy. So I filed a grievance 14564878 against Grosset. But you know what? Grievance coordinator Holfey, Superintendent Oberlin, and Assistant Secretary of Corrections Ron Frakes still upheld Grosset's actions. By upholding Grosset's actions, this Holfey, Oberlin, and Frakes, they completely ignored all the things that they had said before about the talking request only applies, quote, if a conversation takes over one half of the session, or, quote, only applies to prolonged conversations, or, quote, brief encounters are permitted, and saying prisoners may talk, quote, 15 to 20 minutes without having to fill out a talking request or be bothered by Grosset. They just ignored everything they had said before. Not only do each of these characters sound like a bunch of retarded nutcases, but from the legal perspective, the courts have made it abundantly clear that prisoners have a right to help each other in the law library without fear of punishment. Another reason why Walla Walla officials blocked my ability to litigate this lawsuit, it became apparent to me when prisoners who come from Walla Walla's close custody units to the medium custody units where I am, they started telling me that they're still not allowed to talk in the Walla Walla close custody law library. Right now. This is so sad. They don't even know how to stop it. Yvette Stubbs, she worked in the law library on days when Grosset didn't show up for work. On those days, prisoners would ask her all sorts of questions. And a couple of times, she set aside a question and answer session to take all my questions at once. When I asked her about the intent of this talking request policy, she said prisoners who talk are wasting their own time. I explained to her that we are not trained lawyers, and we don't have lawyers to talk to about our cases. I explained that when we communicate to help each other, then we actually finish our legal work faster. It could take me months to find something that another prisoner already found and already knows, and can simply share the information with me in a matter of just one day, thereby saving months of time. And this in turn reduces the amount of time that I will need to use in the law library, which then creates more time and more room for all the other prisoners. If we do not talk or help each other, then we will all be needing the maximum time, which will leave less time for others. Reducing my otherwise available time just because I share my knowledge with someone else essentially means I must choose between working on my own case and sharing information with others. Obviously, being put under that pressure, there will be less and less prisoners who are, in Yvette Stubbs' words, quote, still assisting others, unquote. You see, the Department of Corrections could not walk into any court saying this dumb stuff. They would have gotten laughed out of court, and the jury would have awarded me a lot of money in order to punish them for being so far out of pocket. Now, I want to talk about the way they stole our books. Between 1982 and 2012, us prisoners, we put a lot of money together in what was called the Inmate Welfare Fund. And we bought thousands of law books that were stored in the prison's law libraries. These were books that were written specifically to help prisoners understand the hard-to-understand law books and to understand difficult legal principles. Most of these books are called, quote, legal treatises, quote, books. They are written by experts to help the reader, especially prisoners, to understand a complicated area of law. It could take a prisoner years, 20 years to learn to fully understand an area of law on his own. But with the help of one of these legal treatise books, the prisoner can learn the law in just a few days. Like I said, we bought these books and stored them in the law libraries because we needed them. In paragraph 115 of my second amended complaint, I talked about how the DOC officials, I talked about how the DOC, they don't provide us access to an attorney to file lawsuits against prison guards and prison officials. And this is why they stopped us from talking in the law library. So we would not have anyone to talk to, no one to help us with our lawsuits. In paragraphs 156 through 158, I talked about my grievance number 166-01964, where Correctional Program Manager Roy
You have 1 minute left.
Okay, well, this Roy Gonzalez removed and destroyed all of our bought law books just because they contain information that can help us win our lawsuits against prison guards and DOC officials. And the Column Bay Correction Center Superintendent Ron Haynes and the Assistant Secretary of Corrections Robert Herzog, they all upheld the destruction of these books. And they lied and said it was okay to remove them because they had recently installed a Westlaw computer legal research program that has these materials in them. Well, this was a lie. I could tell, and I knew it, and I saw it coming. Shortly thereafter, they switched from the Westlaw computer legal research program to the LexisNexis computer legal research program that did not have any of this information in it. I saw that coming. Doing this violated the law and clearly violated their own policy, their own DLC policy. Listen, their DLC policy 590.500 Roman numeral 9, capital A and B, still to this day require them to maintain and update these legal treaties, books, and information. My Merriam-Webster Collegiate Dictionary, 11th edition, defines treaties as, quote, a systematic exposition or argument in writing, including methodical discussion of the facts and principles involved and conclusions reached, unquote. There are so many legal treaties books that these thieves stole from a law library. But you know, I can see where they thought they would get away with it, you see, because it says legal treaties books. Even when I first saw this, I thought they were talking about, some agreement between two countries, you know, America and Canada, you know, a treaty. And so people don't really look into that definition. But I looked it up, and that's where I busted them. So just one of numerous examples of legal treaties books is the Washington State practice volumes. There's about 30 or 40 of these. And these books, they teach how to address legal issues specifically in Washington State. And of really special interest to me, particularly at this time when they've been abusing my property. They actually have volumes, specific volumes, that explain how to address governmental abuse of personal property rights of citizens, including prisoners. They tell you everything to do and how to do it in Washington State, based on Washington State law. This is one of the main reasons why Gonzalez took our legal treaties books. The United States Constitution clearly protects our right to maintain our legal treaties books. The U.S. Supreme Court decision in a 1982 U.S. Supreme Court case of Board of Education, Island Trees Union Free School District number 26 versus Pico, in volume 457 of the U.S. series, pages 853 and 870 to 872. It's about a school district taking books out of their school libraries and out of their education curriculum. The school board argued that it is the school board's right to decide what their curriculum will be and what books to use and make available to the students. The Supreme Court said that's true, but once the school board decides to teach a certain curriculum and to make those certain books available to the students then have a right to continue with that curriculum and to continue with those books unless the school board can show a good reason for discontinuing them. If the school board cannot show a good reason for discontinuing these books and curriculum, then they must bring them back. Well, guess what? There's a prison case on this issue also. In the year 2004, a case out of the Northern District of Western Virginia, Klein versus Fox, volume 319 of the Federal Supplement 2D series, pages pages 685 and page 690 to 691, the federal district court ruled that school students and prisoners are in the same position when it comes to authorizing to authority deciding what books to make available to its subjects. So that this U.S. Supreme Court decision in Pico, it also applies to prisoners and the Department of Corrections as well. That Pico, the Fox case is a prison case. So they applied that to the prison down there. And they made the prison bring all their books back. So the DOC policy in Washington State, policy 590.500, it required the Washington Department of Corrections to maintain our legal treaties books. The DOC can't even say they have a good reason for removing them. This means I would have won my lawsuit hands down. They have no reason for removing them. They can't even say that they did the right thing because their own policies say they can't do that. This is the reason why they had to use illegal means to stop me. Without any justification whatsoever, these animals came into our law libraries and ripped up and destroyed all the books that us prisoners had bought and paid for just because they didn't want us using these books to sue them. That's crazy. That is insane. Why are these books so very important to us? Well, I already explained that these books explain the law to prisoners who are not trained attorneys. And one of the main problems is that Washington State requires, now hear me closely, America, Washington State is one of the few states that requires prisoners to submit our papers and arguments that are just as good as attorneys. Yeah, I said that. This is restated in a 2019 Division II Washington Court of Appeals case. It's Rogers versus Quality Loan Services Corporation, published in volume 1737 of the Washington Appellate Lexis Reporter at page 10, where the Washington Court of Appeals says the state courts, quote, must hold pro se parties to the same standards to which it holds attorneys, unquote. This has been the law as far back as 1983, as shown in the Washington Court of Appeals Division II case, In Remarriage of Worley. This case is published in volume 34 of the Washington Appellate Reporter at pages 344 and 349. So, America, think about this for a minute. Our court papers have to be as good as attorneys, which almost is impossible, by the way. We try hard to do as good as we can by purchasing self-help legal treatise books that explain the law, explain legal procedures in a way that we can understand them. And then the DOC takes our books away in total violation of their own policy, 590-500. And when we try to regroup and talk amongst each other and share our knowledge, then they tell us to stop talking. Not only is what they are doing unlawful, unconstitutional, and crazy, but it also shows how much disrespect they have for the rights of prisoners and how far they will go to stamp out our rights and continue their corruption and their abuses. Each and every one of you out there, you can help us began to reverse this trend of this corrupt Department of Corrections by making phone calls and sending letters or emails to representatives and officials that I have provided at the end of my presentation today. Remember, us prisoners pay for these books out of our own pockets. And DLC Policy 590-500 says DLC has to maintain them. They can't be throwing them away. They threw them away because you people out there paying their salaries with your tax dollars, you haven't been getting on them about their abusive conduct. You know, they may try to get you to believe that the few books they have on the Lexis Legal Research Program and our secures tablets is everything that we need and everything that they took. But I tell you, that would be a lie. We had thousands of books in the law library that we paid for that are not on our secures tablets, starting with the Washington practice that I told you about earlier. And also the Washington Practice Digest. It's a different book. It's about 60 volumes. And then there's the Federal Practice Digest, which is about 150 volumes. And there are countless more publications. Can't even count them. Because during the process of them destroying our stuff, I asked them were they keeping a record of what they were destroying, and they said no. Think about that. They didn't even write down the stuff that they was destroying. They just destroyed all our stuff and erased them from existence. There must be an audit conducted to determine all of what was illegally taken from us. And they're just going to have to allow us to get all of the stuff that was available back then. And they're going to have to pay for it, not take more money out of our new inmate betterment fund, but they need to take the money out of the Washington Department of Corrections budget and maybe even directly from this Roy Gonzalez and these other characters who went in there and stole and destroyed our books. If any of you will consider helping us prisoners in our struggles, and you want to seek and ask questions to get guidance, then the best way to communicate with me is to place your name onto my securest email list and send me a short note. Now, your name will not appear unless you send a note. Any amount of help, including the smallest amount of help, will be greatly appreciated. Until next time, Greg Brown, 281-829, Washington State Penitentiary, 1313 North 13th Avenue, Walla Walla, Washington, 99362. Thank you.